Ready? Great. Happy New Year, everyone. The Tuesday, January 9th meeting of the Rhode Island Ethics Commission meeting for 2024 will come to order. The first order of business is a motion to approve the minutes of the open session held on December 12th, 2023. Is there a motion?
Second.
Moved by Commissioner Susie and seconded by Commissioner Jones. Roll call vote, Commissioner Peterson,
Aye.
Commissioner Susie,
Aye.
Commissioner Ritchie,
Aye.
Commissioner Centerini,
Aye.
Commissioner Strauss.
Aye.
Commissioner Jones.
Aye.
And the chair votes aye. Okay. The next item is director's report.
Good morning.
Good morning.
So I will first just mention that the live stream will continue through open session and then it will close for executive session. Then we'll come back and reopen the live stream for the report out of matters, votes taken during executive session. So for the director's report, just briefly on complaints and investigations, we currently have 10 total complaints pending right now. We have 3 of them on in executive session today. And as I've been mentioning, you're probably going to see for the next few months, every meeting will probably have something in executive session on these complaints because they all kind of got filed at the same time. So they're all coming to the head of the next few months. With advisory opinions, we have 4 pending and 1 on today's agenda. That petitioner is here. We've had 5 formal APRA requests received since the last meeting, and we filled all of them. Not only within the 10 days that we're required to, but within 1 business day, which is our policy of always trying to do. So all of those were filled within 1 business day. 4 of those related to complaints and 1 to financial disclosure. Just briefly on financial disclosure, online filing for 2023 did go live on January 2nd. So that's ready to go. Anyone who wants to file their 2023 financial statement is free to log in and do so. If any of you want to do that and you have forgotten or lost your PIN number, it's the same as last year. So you can call us or email us. We'd be happy to get you signed up for that. Otherwise, if you just wait till March, then you and 4,000 other people will receive a letter in the mail from us that has your online filing instructions. And it'll tell you when the deadline is, which in this case is April 26th, which is the last Friday in April of 2024. And then the only thing I really wanted to discuss in office type updates, if you remember at the last meeting, I had asked if any of you wanted us to email you an electronic calendar invitation for your Outlook or whatever it may be. And a few of you did. And I haven't done that yet.
We know.
The reason I haven't done it is because I didn't think I had a complete list of everyone who wanted it. And I want to make sure that I don't bombard because it's going to be 16 emails that you're going to receive for one for each calendar invite. So before I do that, which I will have done today, this afternoon, I just wanted to ask one more time, which of you would like to receive electronic invitations to all of this year's ethics?
I did.
And so I have.
I'm so self-sufficient.
I like
Are
doing
you saying they're all gonna come at once, or are you gonna do them periodically?
They'll all come probably over a several minute period of time. Believe, I've looked it up, and unless our newest employee who's really smart can figure out a way to send one email that does all of it, I've never been able to figure out.
No, I don't.
Then you don't,
I do not.
okay, so I'm gonna take you up. So I have Commissioners Peterson, Strauss, and Quinn that are going to receive. Okay, very good. This afternoon. And
Is that it?
that's it.
Any
Thank you.
questions for Jason? The next item is advisory opinions. And we have 1 today. Okay, and there's a sign in. Is it Paul Rodriguez?
Yes, ma'am.
Good morning.
Good morning.
Good morning, Mr.
Good
Rodriguez.
morning, everyone, and welcome, Mr. Rodriguez. This is the sole advisory opinion found at tab A in your binders. The petitioner is a member of the Middletown Town Council. He has asked for an advisory opinion regarding whether he is prohibited from participating in town council discussions and decision-making concerning the proposed revision of an ordinance relating to short-term rental properties in Middletown, given the close proximity between his property and 3 short-term rental properties. Mr. Rodriguez has resided in his current home for the last 29 years. In the past 3 years, 3 houses which are located across the street from where he lives were purchased by the same person who now operates all 3 houses as short-term rental properties. The petitioner represents that Middletown currently has more than 400 short-term rental properties, which he claims has doubled in recent years. The town council has recently begun discussions to address the increasing number of short-term rental properties in town and potentially revise the current ordinance by requiring that short-term rental properties be owner-occupied and house no more than 4 people at a time. Mr. Rodriguez states that a revised ordinance would not impact the value of the short-term rental properties themselves, but rather would likely impact the ways in which those properties may be operated and potentially the amount of income that short-term rental property owners may collect as a result. Mr. Rodriguez further states that a revised ordinance would not impact the value of his own property. He adds that none of his family members, business associates, or his private employer own a short-term rental property in Middletown. No abutters notices were required or sent out in anticipation of the town council's consideration of revisions of the current ordinance. Out of an abundance of caution, Mr. Rodriguez has to date recused from participating during 2 executive sessions and 1 public discussion on the topic. Looking now to the code, the petitioner may not take part in any matter in which he has a substantial conflict of interest, meaning that he, a family member, a business associate, or a private employer would be directly financially impacted as a result of his participation. If a financial impact, be it positive or negative, is not reasonably foreseeable, and what I mean by that is it's more than conceivable and less than certain to occur, then the petitioner will not be required to recuse. There is nothing in the facts as represented to indicate that the petitioner's contemplated official action would violate the Code of Ethics. Mr. Rodriguez does not own a short-term rental property in Middletown, nor does anyone in his family, any of his business associates, or his private employer. Now, if he or any of those others did own a short-term rental property, he'd have to sit this one out, as it would be reasonably foreseeable that his participation would directly financially impact the income of anyone in that group who owns a short-term rental property. But such is not the case. Accordingly, it is the opinion of staff that the petitioner is not prohibited by the code from his contemplated activity as a town council member regarding the proposed revision of the short-term rental ordinance in Middletown. However, should the proposed ordinance revisions extend beyond those described in the draft in a manner in which it would be reasonably foreseeable that the petitioner or any of his family members, business associates, or private employer would be directly financially impacted, Mr. Rodriguez should either recuse from further participation or seek additional guidance from the Ethics Commission. I'm happy to answer any questions or to defer to Mr. Rodriguez as appropriate.
Mr. Rodriguez, you've heard the staff's analysis and recommendation. Do you have any comments or questions?
Go ahead.
Any comments or questions?
I just want to ask our attorney here, do you have any doubt about the representation that the property, his property will not be affected by this change in the ordinance?
I am taking Mr. Rodriguez at his word for his representations, and all advisory opinions are drafted based on the facts as represented by the petitioner. There's no investigation involved. I'm not suggesting that this would be the case, but let's say, for example, that this draft passes and that revised ordinance actually says anyone who lives on the same street as a short-term rental, their value will shoot up or go down. Then this has no value to Mr. Rodriguez. That's why they're based on the facts as represented. And I have no reason to not believe what he is representing.
Thank you.
Thank you.
Mr. Rodriguez, could you address that? I was curious myself.
Yeah, so when Linda called me, when I asked for the opinion, one of the questions she asked was, Well, the reason I asked for the opinion was because I'd received a few emails from some Middletown residents that own short-term rentals. And so, you know, some were like, you should recuse yourself because you live next to one. Well, the whole council would have to recuse themselves because I think everyone except for one person of the 7 lived next to one. And that didn't make a lot of sense to me. And then they said, well, you could affect your property value. So the light bulb went off. I said, you know what, let me just play it safe and ask for an opinion, and either I can or I can't. Either way, I'm fine with that. So the property values are assessed by, every 3 years, there's a revaluation by Rhode Island state law. The first 2-3 year cycles are statistical revaluations. The ninth year, every 9th year, it's a full reval where they knock on your door, and most people don't let them in, but, you know, so that's driven by the home sales, whether it's a full reval or the 2 statistical ones. That's driven by the home sales or the market sales in that area. And based on the type of home. I have a 2-bedroom Cape. You know, the 2-bedroom Cape isn't gonna be the same value as the 4-bedroom short-term rental across the street. There's 2 of them, and there's an apartment in the back, and then there's one that's not within 200 feet. One of the questions Lynn asked me, are they within 200 feet, or you notified, as she alluded to, but that's my opinion on it. I'm not a real estate expert. I've been on the council in my 20th year now, and, you know, we hire the vision appraisal to do it, and that's what we're told, so that's my knowledge of that question. If it affects me, then I don't see how it does, but if it does, then you say I can't, then that's fine.
I would also highlight the perhaps too subtle statement in the draft that states that no abutters notice the consent in anticipation, and that ordinarily happens when someone's property value could change.
Who makes a decision about when an abutter is notified?
So typically, it's a planning or a zoning change of use or something like that. It has to do with planning or zoning. Or say a liquor license, some type of license being granted or transferred. In my tenure in the council, that's all I've ever seen. If it's something that's placed on the regular docket, it goes out, it's in, you know, it's on our website. The docket's a public document. The short-term rental owners of Middletown is an actual group. They formed a group, it's called STROM. It's the short-term rental owners of Middletown. And, they're very, very, aware of the short-term rental, because as they grow, and look, for me, living across the street, it's more of a quality of life issue. It's not, I have to call the cops every day, or it's not, oh, we want to see data. Their position is we want to see data. How many times you can call? That's not it. It's a quality of life issue with the Ubers and the driveway. One of them has one driveway, holds 4 cars. If the first car wants to get out, all the rest gotta back out. They're pulling in and out of your driveway. It's like the whole neighborhood's changed. And, you know, we represent all of Middletown, not 400 short-term rental owners, where probably half of them are Middletown residents. And our job is to represent everybody. So are they located mostly in one area toward the beaches? Sure they are. The majority of them. But again, we represent everybody in Middletown, and they continue to grow. And what we've seen in Middletown is Newport changed their ordinance a couple of years ago, where they stopped short-term rental owners in residential areas. They grandfathered in the ones that were there, because I think by law, I'm not sure you could just boot them out. So, but have we seen that? We've seen more migrate to Middletown because of, not that we're better than anybody, because we live on an island. Some people in other parts of the state might think that. We live on an island, and it's a destination. It's a destination. And so more people are coming to Middletown. Behind Narragansett, we're number 2 in short-term rental owners in the state, and growing. So we need to take some type of action, and I'm just, based upon the emails I've gotten from some residents and some non-residents, I want to make sure that I'm doing the right thing, that's all.
Yeah,
Yeah, I've got, I guess, maybe 2 questions, but this is not an amendment to the zoning ordinance, correct? It's a standard ordinance being
To the
adopted.
ordinance, it can be changed at any time, sir.
And secondly, it affects all long-term or short-term rental owners the same as every other owner.
Correct.
And as far as you're aware, is there any notice obligation for a normal ordinance adopted that isn't a zoning ordinance? Vis-a-vis specific landowners?
Just if it's a change of use, but like you're saying, besides, and one of the things we cities and towns struggle with is every 10 years, we have to adopt a comprehensive community plan, a comp plan. So we're in the process of doing that right now, but the last one we adopted, a lot of times when the comp plan comes back with a recommendation and the council adopts those recommendations, what happens is sometimes the zoning now isn't in compliance with what the comp plan is. So you either have to bring the zoning in compliance with the comp plan or change the comp plan, which you can 2 or 3 times, I think a year or 2 or 3 years to make those two amenable. That's when notices go out, or if it's a subdivision or something like that, a zoning change, an ordinance change, a regular ordinance change like this, whether it's a fee or anything like that, we could change the fee. We don't send out notices for those types of instances.
As I thought.
Yes, I just wanted,
Thank you.
yeah, you're welcome.
Is there a motion to accept the staff's recommendation?
Also,
A second?
Second.
Roll call vote, Commissioner Peterson,
Aye.
Commissioner Susie,
Aye.
Commissioner Ritchie, Commissioner Centarini,
Aye.
Commissioner Strauss,
Aye.
Commissioner Jones,
aye.
and the chair votes aye. Great, thank you, good luck.
Appreciate it. Thanks for your time.
The time again first.
Thank you so much.
Changes it up.
I like to go in.
I'm gonna go Lakeville, Fightful, last thing first out.
Yeah, right, all right.
Okay, the next item is a review and discussion of the fine schedule and your financial disclosure. plans.
Okay, so this is in your packet, right behind tab B. There's a divider that says fine schedule. This arose out of a discussion we had at the last meeting where we started to discuss the fact that there existed a fine schedule for non-filing financial disclosure complaints that the staff initiated ourselves, as opposed to the public can file non-filing financial complaint alleging that I didn't file my financial disclosure, for instance. And if that happened, that the fine schedule would not apply to that. It only applies to those where the staff initiates them, which we do annually. I've discussed before, and just to remind you, that with financial disclosure, as you know, they're due in April. And in the following month or two, sometimes even 3, the commission investigators spread out across the state to find everyone who hasn't filed and get them to file. Telephone calls and meetings and town clerks and support staff. And when we get it down to a manageable number, under 100, under 50, maybe 20 or 25, the last step is, after we've exhausted all of our other methods of trying to get voluntary compliance, we file against the people who we still haven't got to file. And so this schedule applies to those people. It's something that the commission itself had voted on and established with the last time in 2015. And what the current schedule is that for those complaints, if within 10 days of receiving the complaint, if the filer files their targeting statement, if they agree that they're in violation of the financial disclosure laws, and if they agree to pay a $100 fine, we don't have to go back before the commission. With all other complaints, once they're filed, the only way to get rid of them is to bring them before you, either for a probable cause hearing or a motion to dismiss or a settlement. But with 20 cases in some years, sometimes more, it would just clog up the work so much for us to have to prepare that many hearings that we probably wouldn't do it. Because frankly, there's a lot more important work here on our small staff than filing ethics complaints against 25 people for not filing. So it's worked really well. The commission was kind of prescient in 2015. The schedule had been higher before that. It was $500 to settle the case right away, and it rose up to $1,500 after that, depending upon when the person agreed to get all that work done. And some of the commissioners thought I'll bet you could do these a lot faster and get a lot more compliance if there was a real incentive for people to immediately settle their case for $100. And we said, let's try it. And it really worked. And it has worked very, very well since then, which is why we haven't come back to you yet asking to change it. But it's certainly your prerogative to change it. In the 20 years I've been here, I've seen versions of the commission think the fines are too low. Some versions of the commissioners thought they were too high, and it does seem to, crest and change. So if the commission wishes to edit or amend or rescind or do anything with the fine schedule, we can do that. I'm not here today to recommend it, just giving you information. And if you were inclined to do that, we could discuss it today, and then we would have to do it at a future meeting where I would notice it on the agenda for discussion and a vote. Just bring you that for informational purposes.
Questions? Yes.
I'd like to make a comment. I had requested, that the schedule, come before, the commission. I was, as the most junior member, I wasn't even aware that, there was a schedule. My concern, once having looked at the schedule, was, the schedule apparently establishes a set amount no matter what. Like, for example, if the person files within 10 days, it's $100. If it goes to an informal resolution, it's $500. I think that there should be a further discussion, because I was aware of, and I'm sure all the commissioners are, of the comedy case that dealt with the known standard that has to be found. But as part of that case was also consolidated with case Luby. And I'm aware of the Luby case because in my many years ago, many years ago, I represented Luby as part of my duties with the Warwick City Solicitor's Office. Luby was a member of the Board of Canvassers. She also then filed papers to run for the ward committee, Republican ward committee. What happened was she certified her own declaration and the gathering of certain signatures in her capacity on the Board of Canvassers. The commission found that a violation and made as part of its order that she either immediately resign from the Board of Canvassers or from the ward committee. And if she failed to do so, there would be a $500 fine. That was litigated in the Superior Court, went up to the state Supreme Court. Her appeal was consolidated with comedy. The Supreme Court sustained the finding of a violation. But the Supreme Court stated that the declaration as to the penalty, in the words of the Supreme Court, was somewhat rigid.
Can I just call to your attention the language that does give discretion to the executive director?
Right, that's on the ability to pay.
Yeah.
I'm aware of that. I'm aware of the discretion, but the discretion is delegated to the executive director. But where there's a mandatory minimum, and if there's only an exclusion for an ability to pay, I have concerns as to whether that is somewhat rigid.
Would you like to bring this? Would you like to take up Jason's suggestion that we bring
I
this
would.
back?
That's why, that's my explanation as to why I would like to see it so that the other commissioners can refresh their recollections as to that case.
In the motion for that.
Oh, it just needs to be placed on the agenda.
Sure.
But I'd like to ask.
Yeah,
That discretion that staff retains is pretty broad, isn't it? It's not merely based on financial inability. It says in here, the finding of unique circumstances,
Right.
correct?
I can, and so just to explain that a little bit more, we purposefully left it broad. Unique circumstances a lot of things could fit into that. And so I'll just speak from practical experience about what some of those unique circumstances have been and how that works. So our investigators, once we get into these complaints, we finally are able to reach those people who we haven't been able to reach in a long time. And the investigators have a one-on-one conversation with those people. And this is where they almost become more like social workers than ethics investigators, right? These are, and the conversations are like this: what's going on? Have you gotten our letters? Why aren't you, have you, I've left you voicemails, like, what's happening in your life that you can't get this done? And then they hear, well, I've been in the hospital, or my parents have been in the hospital, I'm going through a divorce, or I'm having medical issues, or I'm in hospice care, or, I mean, I couldn't count on both hands the number of unique circumstances that we hear with these types of cases. And in those cases, we very often don't issue fines. The answer is, can you at least file your form? Sometimes the answer is not without help. And they will go out and notarize their forms for you. We had someone who was in prison this year. That was a unique circumstance. Our investigator went to the ACI and helped that person file his financial disclosure statement. So those are that's the types of efforts that we're using for unique circumstances. We are never going to make someone who is in hospice care pay a civil penalty, or someone who is, in the hospital with serious issues. We just would never do that, and we never have. So that's just so everyone understands that, even though, I hope we always have this unique circumstances clause in any schedule, and as long as it's written broadly like that, I'm always going to read it broadly and apply it that way until the commission tells me I can't do it.
I think that answers my question. As a new commissioner, I wasn't aware of any of this.
yeah.
I wasn't aware that there was a schedule for fines.
Right. And it brought to my attention in reading this, that there's also a schedule of other kinds of fines, correct? That for other code violations, or,
We don't really use a schedule for especially for substantive, that is really the commission's discretion. The statute gives you authority to impose up to $25,000 civil penalty for each violation. So it could be a $1, and the way we've always explained it to the commission and explained it to others is that on a case-by-case basis, the commission weighs the willfulness, all those types of factors.
in my experience, when we have set different fine levels, you have educated us about the range and why. And I just wonder if that's something for new commissioners before we reach that moment. Your question was a great question,
Yeah.
because I think we take for granted that you come, especially with the tremendous legal experience that you have, that you will know things, and that's, for us, it's important that we take the opportunity to think about what are the other things that it's good to refresh our own understanding of, and then bring here almost in this way, just in an informational way, maybe thinking through what those might be.
I think it's really important, and we try to do that. Even today with, we're having, a probable cause hearing. Since we have new commissioners, part of that presentation will be what the probable cause hearing. We're not gonna spend a lot of time doing it, and we know that our judges know what probable cause is, but.
It's always good for the chair to be reminded
Right.
about what legal or procedural things are, for sure.
But we try to take that into account, as we do.
So maybe we could think through what some of those other things might be. So thank you for bringing me, yes. Okay, yeah.
My question is, we have a distinction between a 10-day response period and a later response period. In the notice that you send to violators, do you make them aware of that fact? That if they come quickly, they're gonna get a better deal than if they come later?
We send them a copy in the packet, we send them with the complaint, they get a copy of this schedule. Included in it. And in the same way, speaking of unique circumstances, if we find out that for some reason the mail didn't get delivered for, it's 10 days, but if it's 11 days and then we're still gonna take it, right? Or 13 days, so it's not, we're not robots.
My question was a little more aimed at you giving them both the hammer and the
They know.
layout. Right.
If they care to read the materials, that's, if they care to open the envelope, the information is included.
Any other questions? Right, thank you.
Okay, thank you.
Thank you, Jason. Okay, the next item is a motion to go into executive session to which take up a motion to approve the minutes of the executive session held on December 12th, 2023 pursuant to Rhode Island General Laws 42, 46, 5A, 2, and 4. To take up in re K. Joseph Shikarchi, complaint number 2023-3 pursuant to Rhode Island General Laws 42, 46, 5A, 2, and 4. To take up in re Frank Brown Jr., complaint number 2023-4 pursuant to Rhode Island General Laws 42, 46, 5A, 2, and 4. And in re Denise Brown, complaint number 2023-5 pursuant to Rhode Island General Laws 42, 46, 5A, 2, and 4. And then return to session. Is there a motion to go into executive session?
So
Is there a second? Second. Roll call vote, Commissioner Peterson,
Aye.
Commissioner Suzie,
Aye.
Commissioner Ritchie, Commissioner Summerini.
Aye.
Commissioner Strauss. Commissioner Jones, and the chair votes aye.